A nursing home just handed you a thick stack of papers. 30 pages, maybe 40. Your parent is being wheeled past the nurse's station. Someone places a pen in your hand, and on page 17 there's a small box. Guarantee of payment. 3 words. The room feels cold. The administrator is smiling, waiting. If you sign this, are you personally on the hook for every dollar your parents' care will cost? For $100,000 a year? For everything? Here's the answer. Federal law has already written, no, they cannot make you sign that box. It is illegal to require. And the law that says so isn't buried in some obscure memo. It sits at Title 42 of the Code of Federal Regulations, Section 483.15. 42 CFR 483.15. And it is the one signature a nursing home cannot trap your family with. The fear is not irrational. Families hear the same story from friends, from online forums, from the intake coordinator who slides the packet across the table and says, "Just sign here. It's standard." The average private room in a nursing home costs more than $108,000 a year. A semi-private room runs north of $94,000. Medicare doesn't cover long-term custodial care. Medicaid requires the resident to spend down nearly everything first. And in that gap between what insurance pays and what the facility charges stands the family member holding the pen. The myth is simple. If you sign anything in admission, you become personally liable. Your savings, your home, your wages, all exposed. Debt collectors know this myth. They use it. They send letters addressed to adult children, demanding payment for a parent's stay, quoting amounts of $13,000, $29,000, $47,000. The letters are written to sound like final judgments. They are not. They are fishing nets, cast into the water of confusion and guilt, hoping to pull back something the law does not owe them. The real protection starts with the statute itself. 42 CFR 483.15. The rule is part of the Nursing Home Reform Act, passed in 1987 as part of the Omnibus Budget Reconciliation Act. It applies to every single nursing home in the United States that participates in Medicare or Medicaid. That is more than 15,000 facilities, 97% of the industry. The regulation states, and I will read it verbatim so you hear the exact words, a facility must not require a third-party guarantee of payment as a condition of admission, expedited admission, or continued stay. Read it again, slowly. A facility must not require third-party guarantee of payment, condition of admission, expedited admission, continued stay. The law covers the moment you walk through the door. It covers the moment the facility tries to move your parent from a hospital bed to their wing faster. It covers every month after. No family member can be forced to sign their own name onto the bill. Not as a condition of getting care. Not as a condition of keeping it. So why does the box still appear? Why do intake coordinators still push the packet across the desk and point to the line? Because the prohibition is on requiring the guarantee. The form can still be in the packet. The box can still be printed. And many facilities have learned exactly how to frame the request so it feels mandatory when it is not. They relabel it. Voluntary contribution agreement. Family responsibility, acknowledgement, resident representative financial obligation. Different words. Same trap. They bury it on page 17 of the 30-page packet handed to you while your parent is being transferred, while you are exhausted, while you are terrified of saying the wrong thing and having the admission denied. They tell you it's standard. They tell you everyone signs it. They sometimes imply, without quite stating, that Medicaid requires it. Medicaid does not require it. Federal law prohibits requiring it. Then if a family member signs under that pressure, under that implied necessity, under that false choice between signing and watching their parent be turned away, the signature may be worthless, may be unenforceable, and the agency that polices this has put that finding in writing. In 2022, the Consumer Financial Protection Bureau issued Circular 2022-05. The title, Debt Collection and Nursing Home Debt. The circular warns debt collectors that attempting to collect a nursing home debt from a family member who signed an admission agreement but who did not voluntarily assume personal financial liability may violate the Fair Debt Collection Practices Act. The CFPB's position is clear. A signature on an admission form is not automatically a personal guarantee. If the facility required the signature, coerced the signature, or disguised the signature as a condition of care, the personal liability is unenforceable. Trying to collect it is illegal. The circular puts debt collectors on notice. The federal government is not just banning the requirement, it is policing the collection that follows. This is the moment to look at the exact words on the page, because there is a distinction that changes everything. And most families don't learn until the collection letter arrives. There are two roles that sound similar and function completely differently. The first, guarantor. The second, responsible party. A guarantor is a person who promises with their own money to pay the facility's bills if the resident cannot. A guarantor signs their own name, pledges their own assets, and becomes personally liable. The debt can follow them. Their credit can be damaged, their wages can be garnished, and here's the key fact. Federal law says a facility cannot require you to become a guarantor as a condition of admission. Not at the start, not later, not ever. A responsible party is different. A responsible party is a person who manages the resident's affairs. They use the resident's money, Social Security checks, pension payments, Medicaid benefits, to pay the resident's bills. They sign documents on behalf of the resident. They are an agent, a representative, a contact person. They are not personally liable for the debt. The resident is. The resident's estate is. The responsible party is not. The intake form often lists a section, Responsible Party. The facility representative may say, "That's you. You're the one responsible." But responsible for what? For making decisions, for communicating, for handling the paperwork, not for paying out of your own pocket. The distinction is not a technicality. It is the difference between acting as a representative and being hunted by a collection agency. There is a phrase that can shield you in the moment. When the packet arrives, when the pen is in your hand, when the line asks for a signature that might be misread as a guarantee, write these 4 words, signed as agent only. That phrase means I am signing on behalf of the resident, not on behalf of myself. I am not accepting personal liability. I am acting in a representative capacity. Those 4 words create a legal fence around your personal assets. And if the facility pushes back, if they say the phrase isn't acceptable, if they tell you to cross it out and sign again, that pushback is itself evidence. A Medicare or Medicaid certified facility cannot require a third-party guarantee. If they refuse to accept a signature that explicitly limits your role to agent, they are demanding a guarantee, and that demand violates federal regulation. Real families have faced the consequences of getting this wrong. A daughter in Ohio signed her father's admission papers without reading page 17. 6 months later, a collection agency demanded $29,000. Her credit score dropped 200 points. She was facing garnishment proceedings before an attorney cited 42 CFR 483.15 and the CFPB circular. The debt was canceled. A son in Florida was told he had to sign a financial responsibility form or his mother would be discharged. He signed. The bill came to $34,000 after her death. The facility sued him personally. The judge dismissed the case, citing the federal prohibition. But the son still spent 11 months and $8,000 in legal fees getting to that dismissal. The system counts on you not knowing. It counts on the guilt, the urgency, the fear of saying no while a parent waits in a hallway, and debt collectors count on the same confusion when they call 6 months later The CFPB circular is specific about what constitutes a violation: collecting or attempting to collect a debt from a person who is not legally obligated to pay, misrepresenting that a family member is personally liable for a nursing home debt, threatening legal action that the collector cannot legally take. The Fair Debt Collection Practices Act gives consumers a private right of action. You can sue a collector who violates the law. The CFPB has received thousands of nursing home debt complaints, and they are watching. But the guarantee box is not the only trap folded into the admission packet. There is another document they slide across the table, often on the same day, in the same stack: the arbitration agreement. Until 2019, nursing homes routinely required residents or their representatives to sign binding arbitration agreements as a condition of admission. An arbitration agreement strips away the right to sue in court. It forces disputes into a private system chosen by the facility, decided by an arbitrator the facility often helps select. It limits discovery, caps damages, and seals the outcome from public view. In 2019, the Centers for Medicare and Medicaid Services issued a final rule. The rule states a facility cannot require a resident or their representative to sign a binding arbitration agreement as a condition of admission to or continued stay in the facility. The language echoes the guarantee prohibition. Cannot require. Condition of admission: continued stay. The rule also requires that any arbitration agreement be explained in a form the resident understands. It must be separate from the admission contract. The resident must be told they have the right to refuse, and if they do sign, they have 30 calendar days to rescind the agreement, 30 days, in writing, and the facility must provide the rescission form. The same pressure that targets the guarantee box goes after the right to a courtroom. And there are more traps. Some facilities try to charge families for items or services already covered by Medicare or Medicaid. This is called balance billing, and it is illegal. Some try to insert clauses that waive the facility's liability for negligence, for bed sores, for falls, for medication errors. Those waivers are unenforceable and often illegal. Residents have rights that cannot be signed away at the intake desk. The full list of rights was established by the Nursing Home Reform Act of 1987. The right to dignity and respect, the right to privacy, the right to manage one's own finances, the right to be free from abuse, neglect, and chemical or physical restraints imposed for convenience, the right to participate in care planning, the right to voice grievances without retaliation, the right to refuse treatment, the right to access visitors, ombudsmen, and advocates. Every facility must provide a copy of these rights upon admission. They must be posted in a visible location. If they are not, that is a violation on its own. The admission packet is not neutral. It's a document designed by the facility's legal team. Every clause, every signature line, every buried paragraph has a purpose. Some of those purposes protect the resident, some protect the facility's revenue, and some, like the required guarantee of payment, are expressly illegal. So what do you do when you are actually in that room? When the packet is in front of you, when the pen is in your hand, here's the checklist. 1. Read every page. Insist on taking the packet home overnight. A legitimate facility will not object. Pressure to sign immediately is a red flag. 2. Look for the payment section. Find any box labeled guarantor, financial guarantee, personal guarantee, or family responsibility. Cross it out. Write refused. Do not sign it. 3. For the responsible party section, sign only as agent. Write signed as agent for resident's name. If the form doesn't allow that, write it anyway, in the margin, next to your signature, on the line itself. 4. Refuse any mandatory arbitration agreement. Insist on a separate document. Read it. Know your right to refuse and your right to rescind within 30 days. 5. Ask for a copy of the resident rights document. Ask for it before you sign anything else. If the facility cannot produce it immediately, note that. 6. If pressured, state the regulation out loud. Say 42 CFR Section 483.15 prohibits requiring a third-party guarantee of payment as a condition of admission. I will not be signing a personal guarantee. The words themselves create a record. The facility knows them. When you use them, you signal that you are not confused, you are not afraid, and you are not a target. 7. Keep copies of every document you sign. Take photos with your phone. Request written confirmations. If a conversation happens verbally, send a follow-up email summarizing it. Be the person who builds a paper trail. And if the pressure already happened, if the signature is dry and the collection letter has arrived, you do not have to accept it. Dispute the debt in writing within 30 days. Cite 42 CFR 483.15. Cite CFPB Circular 22-05. State that any signature was made as a representative, not a guarantor, and that demanding a guarantee as a condition of admission or continued stay violates federal law. Demand verification that you personally agreed to assume liability voluntarily and without coercion. In most cases, the collection agency cannot produce such evidence because it does not exist. File a complaint with the CFPB. File a complaint with your state's long-term care ombudsman program. File a complaint with CMS. Each complaint creates a record. Each record increases pressure on the facility and the collector. The enforcement machinery is real. CMS can impose fines, deny payment for new admissions, terminate a facility's Medicare or Medicaid participation. The CFPB can investigate debt collectors and bring enforcement actions. The Federal Trade Commission has authority to pursue unfair or deceptive practices. State attorneys general can file suit. And you, as an individual, may have the right to sue under the Fair Debt Collection Practices Act. Real results exist. Families have received letters canceling debts. Facilities have been cited and fined. Policies have been rewritten. The system is slow, bureaucratic, and imperfect, but it works more often than people believe. And when it works because someone knew the regulation number and was willing to write it down. Let's return to where we started. The packet, 30 pages, the pen hovering over a small box on page 17, guarantee of payment. That box is not what the facility says it is. It is not a requirement. It is not standard. It is not a condition of care. It is a test of whether you know the law, a test of whether you will read before you sign, a test of whether fear and guilt, overrule what the federal code has already decided. And the answer the law provides is complete. The box cannot trap you. The signature, properly written as agent, does not bind you. The debt collector's letter does not prove a valid debt. The regulation is clear. The circular backs it. The reporting pathways exist. You're not just a family member holding a pen. You're the person who knows what 42 CFR 483.15 says. You're the person who writes signed as agent only. You're the person who knows the guarantee box was never supposed to be signed at all. The pen drops. The packet closes. The room changes. The case on that small box, it's closed.